we kindly request that you go to the bottom of your screen on the interpretation icon, select the language that you are comfortable with to enable you to follow the proceedings properly. And the naming conventions again, we start with the country, then followed by your name, or you start with the organization that you represent and then followed by your name. Can I request that we please switch on the videos so that we can check if we are all ready for our broadcast? The session is going to be streamed live on YouTube, Facebook, and Twitter, and also recorded for later broadcast on Parliament TV, which is found on DSTV channel 408. So I request all the participants to please ensure that every time they take to the platform, Mr. Chwara, I would ask you to help me with that as well, please. Every time participants take to the platform, please remind them to switch on their videos. It is very important for our broadcast. I see that there's a camera that's on there, Mr. Gif Biene. Could we kindly request you to please use the landscape side of the camera instead of the portrait to ensure that you are properly visible? You move it around to landscape. There you go. Thank you very much. And also ensure that when you do your framing on the video, leave a little bit of space, just a little bit above you, and then that should be clear on the side, and also your head and shoulders are in the picture. We are going to be using your name tags here when you do the broadcast, so we don't want your name to be appearing on your mouth. So ensure that there's a little bit of space, your chin, between your chin and your shoulders. At least there's enough space for your name to be featured in there. Thank you very much, Mr. Soloniana. Soloniana from Madagascar. Could you kindly use the landscape version, side of your phone, of your video instead of the portrait one? Yes, instead of having the phone this way, have it this way. This is the landscape side. Thank you very much. Now we've got the video full on. Can I have more cameras on, please? Can I kindly check with our legal drafter for today to see if the camera is properly framed? Thank you very much, Mr. Nyamandini. Thank you very much, Madam Mishito. I'm not sure if I'm pronouncing your surname correctly.
Very correct, very correct. Well done.
Thank you very much. Can I kindly ask you to rename your gadget as well? Start off with either the country that you represent, followed by your name, or you start off with the organization and then followed by the name, please.
How do I do that?
You go to your name. If you go to your name on the screen and then you click on it, it should give you a renaming. You see where there's a list of names? Participants. You can either go there and then you can, or let me see. Which view are you using now? Are you using a laptop or a
I'm using a laptop.
Laptop. Okay. There should be on the where's this now? Is it the top? I'm trying to figure out from mine now because are you using the view that you're using? Is it for your picture only or everyone's pictures? The gallery pictures?
Oh, I can see more pictures than mine.
Yeah, go to your name and then just right click on it. It will have red buttons that have three buttons. And then when you click there, it should give you an option to rename at the bottom. Scroll down to, you'll get a
Yes, I've seen it.
yeah. You
Mhm.
rename it.
So what should I include?
Include either you include your country or the organization
Or
that you represent.
organization.
Yeah,
Okay.
country organization.
Thank you.
Yes.
All right.
Thank you very much. Can I one last time request all participants, distinguished participants that are on the platform, to please switch on their cameras so that can be able to establish. Madam Shido, can I ask you to please, in terms of your framing now, we can only see you on the corner and half of your face. So if we need to see your entire face with a bit of shoulders as well.
So what do I do? Push it back?
Yeah, push it towards you. Yes.
Like that?
Towards
That
you,
better?
yes. That's much better.
Okay.
Thank you very much. That's much better.
Okay.
Thank you very much. If we can keep it like that, we'll be good to go.
Okay.
Thank you very much. Thank you very much, Madam Arawa. Can I ask you to rename, include your country or the organization that you represent, please, on your name?
So how do I do this?
If you go to where your name is on top of your screen, I think, and then you go to there will be 3 buttons. Oh, my apologies. My apologies.
It's okay.
The facilitator of today.
Angola, is Angola represented in the meeting? Is Angola represented? We go to Botswana. Is Botswana represented? Botswana. We go to DRC. Is DRC represented? DRC. Eswatini. Is Eswatini represented in the meeting? Eswatini. We go to Lesotho. Is Lesotho represented? Lesotho. We go to Madagascar. Is Madagascar represented?
Bonjour.
Good morning. Yes, we are present.
Good morning. Welcome to the meeting. We go to Malawi. Is Malawi represented?
Yes, facilitator. I'm from Malawi.
Thank you very much. We go to Mozambique. Is Mozambique represented? Sorry, I jumped Mauritius. Is Mauritius represented in the meeting? Mauritius? Do we have representatives from Mauritius? Mozambique, Namibia, Seychelles, South Africa, then we go to URT, United Republic of Tanzania, Zambia, and lastly, Zimbabwe.
Zambia.
Thank you. Zambia is there.
Zambia is there, yes.
Thank you. Thank you. Welcome to the meeting. Thank you very much. So we are represented by Madagascar, Malawi, and Zambia. We hope other colleagues will join us as we go through our meeting. Zimbabwe is represented. Thank you. Thank you very much.
Tanzania is also represented. Thank you.
Tanzania is also there. Thank you. Thank you. Then we'll perhaps kindly ask.
Here.
Sorry?
Though I'm not from Parliament, but Lesotho is here. I'm a
Lesotho. Thank you, Lesotho. Thank you, Lesotho. When we give you the platform, perhaps we'll ask you then to kindly introduce yourself as you are speaking in terms of your name and the organization that you are representing. Thank you. In the interest of time, let me jump straight to the welcome address. And the one to give us the welcome address is none other than our Secretary General of the SADC Parliamentary Forum, Madame Boemo Sekoma. Madame Boemo Sekona, I'll leave this time to you to give us the welcome address.
Good morning, delegates. Let me establish the protocol for this morning. Distinguished President of the SADC Lawyers Association, Mr. Maxwell Xolani Botswana, partner of law firms Botswana, Loon and Connellan and Botswana. Mr. Daniel Grimm, our legal drafter for the SADC Model Law on Public Financial Management, members of the Technical Working Group of the SADC Model Law on Public Financial Management, meeting facilitator, Mr. Pepukai Chivori, the Director of Budget Office in the Parliament of Zimbabwe, staff of the SADC Parliamentary Forum and staff of national parliaments, SADC citizens following proceedings on various social media platforms, members of the media in your diversity, distinguished participants, good morning, bonjour, bon dia. Dear colleagues and distinguished participants, I send fraternal greetings from the SADC Parliamentary Forum to the SADC Lawyers Association and Financial Lawyers of the region. Welcome to this August event held under the auspices of the SADC Parliamentary Forum. As you are aware, the Forum is accustomed to holding a series of stakeholder consultations prior to the adoption of every model law, and the consultations of the SADC Model Law on Public Financial Management confirms this long-standing collaborative practice. Distinguished colleagues, first, I wish to thank you for finding the time to attend this crucial consultation. It is indeed laudable that the SADC Lawyers Association, as well as financial lawyers, are interested in the elaboration of a framework for public financial management. Besides being at the center of litigation concerning financial issues, indeed, although legal reforms affect the future and is by nature prospective or forward-looking, without affecting current litigation, the voice of lawyers to the framing of legislation and regional legislative instruments is always important. Distinguished colleagues, the SADC Parliamentary Forum firmly believes that the SADC Lawyers Association and financial lawyers have a momentous role to play in the discourse relating to the consolidation of the democratic drive in the SADC region. Indeed, democratization is highly dependent on social and intellectual movements, such as the SADC Lawyers Association, which continuously discuss central themes such as the rule of law, constitutionalism, or respect for human rights, all of which have inherent linkages with public financial management. And let me at this point thank my colleague, Mr. Stanley Nyamahinda, for such a productive collaboration. Dear colleague, in turn, robust public financial management leads to good governance. That is the foundation of a democracy. Regarding public financial management, the intellectual movement of financial lawyers, led by the SADC Lawyers Association, will undeniably have expert guidance to confer on the provisions of the model law, as well as their enforcement in litigation through the court system of the region. Furthermore, financial lawyers are regularly involved in litigation on financial irregularities and misappropriation, and will be able to confer guidance on the adequacy of relevant provisions of the SADC model law on public financial management. Financial lawyers are also acquainted to the court process and will be able to advise on court procedures and evidential issues that may arise with the litigation of financial crimes. They also thoroughly understand the evolving legal dynamics governing money laundering, the necessity to preserve chains of custody, the cross-boundary nature of certain financial transactions, as well as illicit financial flows that transit through Africa. To cite but a few areas of knowledge which hover around the theme of public financial management. Dear colleagues, financial lawyers understand the wide spectrum of public financial management related issues, from civil orders concerning recovery of property to the prosecution of financial crimes and other public financial related offenses. Moreover, they understand the whole public financial management process of the state, which concerns mainly the budgetary exercise, the oversight powers of Parliament through the Public Accounts Committee, the management of the Consolidated Fund, and the functions of the Auditors General. In most jurisdictions, financial lawyers are also appointed to key financial positions, such as the CEO or chairperson of the Financial Services Commission, the Registrar of Companies, or the CEO of state investment companies due to their legal knowledge and expertise in the world of business affairs. Financial lawyers are thus multi-talented individuals that have remarkable experience and knowledge on public financial management and are accordingly apt to enlighten the way regarding legislative initiatives on public financial management, such as the model law before us. Dear colleagues, today we kindly expect that you engage openly and frankly with the legal drafter and the rapporteurs on the appropriateness of the provisions of the model law from a litigation perspective. In particular, you may wish to draw particular attention to the provisions regarding appropriation of funds by the state under Part 7 and provisions on parliamentary control under Part 6, which specify the role and mandate of the Public Accounts Committee in overseeing the public financial affairs of the state. You may wish to note that the Public Accounts Committee has the leverage to interact freely with stakeholders involved in public financial management, thus including financial lawyers. Dear colleagues, as financial lawyers who are practicing in the contemporary fast-paced environment, you'll undoubtedly have views on the regulation of cryptocurrency under Part 12. You may also wish to give guidance on the regulation of fintech licenses, which are closely linked to cryptocurrencies and which are likely to influence the financial systems of the SADC regions in the years to come, if it has not happened already. The new areas of financial regulation constitute food for thought as we finalize the SADC model law on public financial management. Dear colleagues and distinguished participants, I would like to underscore that a financial lawyer, or as financial lawyers, you may be working in public or private spheres. While domestication is usually a matter for the executive, financial lawyers are involved as liberal professionals in calling to action to government to do what is right for their country. Indeed, if today financial lawyers find that the public financial model law is bringing something new to the table in terms of enhancing good governance, improving the systems of checks and balances between the executive and parliament, and thus assisting actively the consolidation of the democratic drive, then you are invited to explore the possibilities of calling the executive to act in favor of domestication. And this by virtue of your independent capacity as legal professionals. In addition, you'll be called upon by the SADC Parliamentary Forum through the SADC Lawyers Association to interact with the Regional Parliamentary Model Laws Oversight Committee, which is the dedicated organ of the forum, to monitor the domestication of model laws through scorecards and other advocacy tools. The SADC Parliamentary Forum firmly believes that the SADC region is a region of wonders and is a powerhouse of potential. We cannot let progress be undermined by financial mismanagement, by fraud, corruption, and other public financial management irregularities. Dear colleagues, today, the SADC region stands at the crossroads of progress, innovation, and the visionary aspirations articulated in Africa Agenda 2063, which are intricately linked to the Sustainable Development Goals. In this regard, the Forum is committed to continue working with the SADC Lawyers Association and financial lawyers to drive and harness the legislative momentum required for the model law to become a reality and be gradually domesticated. With concerted efforts from determined stakeholders, the SADC region will undoubtedly rise to the height of its ambitions for economic benefit of the SADC citizenry. With these few hopeful words, I wish you a pleasant session and fruitful deliberations. I apologize, I had to record this intervention purely because of competing priorities. I thank you and have a great day.
Thank you very much to Madam Boemo Sekoma, our SADC Parliamentary Forum Secretary General. Indeed, she raised very important points that the consultations have become part of the modus operandi of the SADC Parliamentary Forum. And in that, it entrenches ownership of these model laws across the countries because they are widely consulted. And she highlighted the importance of our financial lawyers with their experience and knowledge in public finance management. They will really assist and guide us, guide the legal drafter, guide the rapporteurs from a litigation point of view, and from also highlighting the key aspects in the model law relating to cryptocurrency regulations relating to fintech financial systems. Thank you very much, Madam SG, for that. Without wasting much time, we move straight to our keynote address. And we have a representative of the SADC Lawyers Association, and Mr. Maxwell Tolani Botswana, who is the president of the SADC Lawyers Association, is ably represented by Sashi Nchito Kateta, who is the ex-court treasurer and council representative of the Law Association of Zambia to the SADC Lawyers Association, and is a senior partner of Nchito and Nchito Advocates in Lusaka, Zambia. I hope I have pronounced those names correctly. I give this time to you, Sashi Nchito Kateta, to give us the keynote address. Thank you.
Thank you very much, Mr. Facilitator. And you tried to pronounce the names correctly, except the last one. It's Kateka. K-A, yes, K-A-T-E-K-A. Thank you very much. It's indeed my honor and privilege this morning to represent the president of SADC Lawyers Association, Mr. Maxwell Botswana, who is not able to join us this morning. And as I present his remarks, please allow me to ride on the way established by Madam SG, and I will proceed into giving the remarks. Thank you very much. As SADC lawyers, we believe that this legal drafting exercise is aimed at curbing corruption to increase the chances of domestic resource mobilization in SADC member states. It correlates with the core pillars of strategy of the legal profession enunciated in SADC Lawyers Association strategic plan. The focus of the legal profession is shifting from mere policy development to institutionalization of global accountability frameworks. Measurable outcomes based on sound policies and laws with accountability are the so key.
I'm sorry to interrupt you, madam. Can you kindly slow down so that we may interpret you? Madam, can you slow down, please?
By our government to stem corruption and to hold accountable those public officials that do not meet the minimum standard of their performance is the greatest impediment to ending poverty on our continent. We realize that financial management is not an end itself. It is, however, crucial to the successful functioning of any country since it relates to how resources available to the fiscus are used. Considering that the public sector is service delivery driven, the analysis and evaluation of management performance is different and more complex than that of the private sector, which is driven by profit incentives. In the public sector, economy is measured by the relationship between quantity and quality of resource inputs and its related cost. Efficiency is measured by the relationship between resource inputs and outputs, while effectiveness is measured by the extent to which outputs accomplish set outcomes. Appropriateness is measured by the extent to which program outcomes meet the real needs of the community, which also form part of government's priority. A public financial management framework has subordinate treasury regulations, and their implementation interacts with the various relevant treasury components. Lawyers, therefore, have a key role to play in each of these processes that must be informed by the key competencies and capacities that this exercise helps to identify. In this regard, workshops will be required to increase lawyers' understanding of regional and international legal instruments and to build their capacity to foster the justice system's involvement in the control of mechanisms of public finance and the fight against impunity for mismanagement of public affairs. Madam SG, key questions based on the ethics arise on the role of lawyers. Are they beholden to lawyer-client privilege when during the course of advice a public sector client violates the law and misappropriates public resources? Is it enough to simply renounce agency, and what more can be done? Further, there is a challenge of our colleagues in the public service. Do they honor the code of ethics and ignore the commands of their employer? Are there safety nets for the whistleblowers under the public management finance policy? From this brief interrogation, it is clear that the core principles of the public finance management framework must be embedded in the respective codes of ethics of the legal profession. These are readily available tools for fostering the implementation and knowledge of public finance management within the legal profession. As we move towards concluding these remarks, I continue to hammer on the role of lawyers.
Conclusão do...
So I think someone needs to mute their mic.
Sure, you can proceed.
We continue to hammer on the role of lawyers in implementation of the public finance management. Lawyers play a critical gatekeeping role based on the intrinsic monitoring role they perform as advisors and facilitators of financial transactions, policy development, and interpretation against correlating regulations and institutional requirements. In this regard, I call upon our conscience and pledge to the constitution of our respective countries to be our master in the implementation of the provisions of the public finance management laws. Lawyers can also pick up the gaps in the law that impede its smooth application. Through public interest litigation, the involvement in law development and reform, it is possible to contribute to further alignment of the model law with domestic and international principles. I invite you to engage in robust debate and make critical input from across all your areas of expertise as they relate to public finance management. It is my hope that this event marks the beginning of a long and fruitful relationship and interactions. It is my understanding that the formalization of the collaboration between SADC and SADC Parliamentary Forum is underway. I look forward to finalization of this process and development of further mutuality between the two organizations for the benefit of our region and its citizens. I thank you all for taking time to come and participate in this consultative platform and wish you all success and prosperity in your further endeavors. Thank you very much.
Thank you, Madam Sashi Nchito Kateka, for that keynote address. That is a call to action for our lawyers, financial lawyers, to really assist in the drafting of this model law to ensure that it is well couched so that we curb corruption in the region and we increase domestic resource mobilization. And also that we are advancing the principles of economy, efficiency, effectiveness, appropriateness in our engagement in our public finance management roles. Thank you very much for that address, Madam. And without much further ado, we move to the next item on our program, where we are going to see a video clip that will be played, and the video clip resonates well with why we are gathered here today. So let's pay attention to the video clip, and that video clip will also assist us as we engage and partake in the discussion for this model law. IT team, kindly assist so that we partake in the viewing of this very important video.
This is not about a campaign against multinationals just blankly. We would like to see clean businesses who come here, pay their taxes when they work with us. The idea of reporting all their profit in a small headquarters where there are only 2 or 3 people working there and overlooking the entire operation, which is 60-70% of it is happening in this continent. We would like that to stop.
Curtail abusive transfer pricing, for example, trade misinvoicing, for example. There's a lot of work that remains to be done.
We must indeed achieve the objective of stopping the bleeding, of retaining these resources on the continent, which are illicitly flowing out of the continent.
These scenes are not so dissimilar to one that happens every day across the African continent. A businessman goes into a bank and makes a transfer of funds to an offshore company. Little questions are asked and millions are funneled out of the country electronically in a matter of minutes to a territory where little or no tax is accrued. This scenario is also surprisingly legal. A senior government minister collaborates with a mineral company executive to stash money and profits earned illegally in a foreign bank. A woman gives $5,000 to a man in the hopes to get her whole family across the border illegally. This is a human trafficker. He deposits the money in an overseas bank where it is cleaned and legitimized. All these are examples of illicit financial flows, or IFFs. Money leaving the continent, being funneled into international, global, already developed capitals and depriving African national economies of vital liquidity and resources. The campaign to stem IFFs, or previously termed capital flight, is by no means a new phenomenon and has recently received a boost by the revelation of the Panama Papers, an unprecedented leak of over 11 million files detailing wealthy individuals and numerous multinationals exploiting secretive offshore tax regimes has elevated the issues of illicit flows to the forefront of the global agenda and media scrutiny. The establishment of the high-level panel represented a watershed and new strategy to combat the illicit flows.
All started on a Sunday in Malawi. We were preparing for the opening of the African Ministers of Finance, Planning and Economic Development Conference in 2010. The room was full. We were really surprised with the response. And those who attended, they said, no, this has to go to the ministerial proper the following day. And we had a 2-hour discussion on it. And African Ministers of Finance, in their wisdom, they said, no, this is a development issue that is too important for the continent. We cannot allow this continent, the poor part of the world, to subsidize the rich part.
I sometimes refer to it as being like a hydra with many heads. And a strange hydra, when you cut some heads, by the time you get to the 7th head, the first one has regrown. It's so dynamic, it keeps on changing shape and form. So we have to be resolved to the fact that we will always be chasing, finding out new ways of illicit financial flow and trying to deal with them. That's the first thing.
GFI analyzes illicit financial flows, not only out of Africa, but out of other parts of the world as well. We did a study of illicit money going out of Africa. We were asked by UNECA to come and discuss it. We did so. This is going back 5 or 6 years now. UNECA was frankly fascinated with our analysis that the commercial component of illicit financial flows is bigger than the corrupt component of illicit financial flows, because quite honestly the media had been for years enjoying its criticism of Africa for the amount of corrupt money that is going out. So we came along and said, yes, corruption's a problem, but the biggest part of this is commercial.
According to GFI, these are the 3 clear definitions of IFF as seen before earlier: corruption, criminal, and the commercial aspect. The estimated 50 to 80 billion US dollars that the African continent loses annually in illicit flows is about double that what the continent receives in ODA, or official development assistance. Moreover, based on the methodology of the Economic Commission for Africa, abusive transfer pricing and misinvoicing, the underreporting of amounts produced and profits made are another major source of commercial illicit funds lost forever.
When we then presented our report to the African heads of state and government, they adopted the report in full, adopted the recommendations that we had made, and then decided, as African heads of state and government, to follow up on the implementation of what had been the recommendations, which had then been adopted as decisions of the AU summit.
There has been a confluence of forces that have really given this a boost. And also, as you know very well, the birth of this was looking for how the continent can finance itself. And one of the immediate low-hanging fruits was the issue of illicit financial flows out of Africa. So I think it's firstly therefore leadership, secondly circumstance, and thirdly the strategy brought to this by the ECA.
So it's been an exciting work, and the whole purpose is to promote African development. And how do you promote it? There has to be resources. It's resource mobilization. And in that regard, what are the obstacles to resource mobilization? And one of the obstacles is illicit financial flows from the continent.
There is really nowhere else on the continent where there is a plug-in for policy and legislative shifts that we need to make on the continent to defend our outflows, other than currently the high-level panel. And they're doing a tremendous job because they've gone from beyond the report and letting it gather dust in somebody's office, but also looking at the systemic work that needs to be done, work with regards to policy and policy shifts, both at the ministerial, Ministry of Finance level, as well as bringing in civil society and regional organizations to make the necessary policy shifts that we require. It's good work that they do.
Even before the Panama Papers, they have managed to elevate the issue of international financial flows, at least, or illicit financial flows from Africa, at least, into an international issue. It's a global challenge also. So they anticipated the Panama Papers. Perhaps they'll be similar in future, but already the work of the panel has already put this into the fore, has already elevated this into a global issue, a global challenge, something requiring global action.
Illicit flows have steadily increased over the years in scale and magnitude, and fundamentally undermine our ability on the continent to achieve our sustainable development goals, impede transparency, and risk further increasing inequality and poverty. The campaign to stem IFFs is now galvanized under a wider context, incorporating an array of actors from civil society, tax and governance advocates, and government and parliamentarians.
We wanted it on the global agenda. It is now on the global agenda. So there are many people who are part of this campaign to stop the continent bleeding of these resources. So it's governments, it's civil society, it's business, it's everybody.
Our role we see as bringing the interests of citizens on the table to ensure that the design of policies that will ultimately curtail illicit financial flows and ensure domestic resource mobilization are policies that are not also at the same time leading to increased inequality and having a situation where it's already the poor that are already carrying the burden that are going to suffer out of that. And for that to happen, you need to have civil society organizations in the room to create that critical mass of actors to be able to again, demand that the politicians and the governments actually fulfill their commitments, honor their commitments in terms of what they have said they are planning to do to curb illicit financial flows.
Firstly, do you even know that there's IFFs? And if you do, what does that mean to you as a political party? In election campaigns, in parties that are in parliament, because we just say MPs, some come from ruling parties, some from opposition. Those that are in ruling parties, how are you influencing your own ruling party in terms of IFF? But more so, because parliamentarians get a budget for constituencies, are you taking this as an issue at constituency level, where you are saying in terms of mobilization, how do I take this message and explain it to an ordinary African? I mean, Panama Papers came. For Africa, we say they came, they are gone. For most African communities, it has meant nothing. People don't even know what that is. So we are saying at APNIFT, it is your role as an MP to take this message to that lower level, because these are the people that vote and keep governments afloat. If they are not empowered to know what is going on, they are never going to hold governments accountable.
Accountability is also in need of another key building block to fight illicit flows: capacity. Capacity building of appropriate institutions across the continent is key to improving skills and enforcing financial retention.
We begin to see that capacity challenges or the lack of capacity is a critical issue for combating illicit financial flows and stopping the bleeding. In particular, one area where African countries have big problem is actually implementing the legislations and the laws that they have for money laundering and for corruption and for all kinds of activities, illegal outflow of funds. And so we're working very hard to strengthen these institutions so that they can become more effective in dealing with these issues, and they become better coordinated in terms of what they do.
A clear metric on the success of tracking illicit flows is also its subsequent retrieval. Headway has now been made in a number of countries, generating repatriation of funds and the curtailment of aggressive tax avoidance regimes.
But we need even improvements to track it better. Better accounting and international accounting standards, better capacity with customs officials, better capacity in drawing agreements and other things. I mean, even just identifying or tracking will take some effort.
Uganda recently won an international court case against a British oil company, and as a result of that case, gathered $423 million in income that they would have lost did they not have a capital gains tax policy and law in Uganda. Many African countries do not have that, and because Uganda had that law, they were able to go to international arbitration, win the case, and now have that income.
The cumulative effect of strengthening financial architecture, challenging banking secrecy, and reforming common tax orthodoxy reduces outflows and critically increases income on the continent. As the fight to stem illicit flows continues, the policy and legislative shifts being implemented by the panel will inevitably need to adapt to future innovative and more clandestine methods of outflows, preempting a drive to shift not only the legal structures, but also an overall moral offensive on IFFs and their consequences.
You know for a fact that basically everybody in the world is going to disapprove. It might be legal, but if it's immoral, and people understand what that immorality means in practical terms. But secondly, I think there's much greater commitment among governments throughout the world that where legislation doesn't exist, it must be passed. Where it exists, it must be enforced. That you need all of these agreements and benchmarks, standards and all that to ensure that you have both you can have moral motivation, please act correctly, but you must also have the law on your side to say those who don't act correctly, then the law can act against them. So that you see even the definition of what's illicit in terms of the law, as people understand the loopholes and so on, and the impact, the negative impact of these illicit flows in terms of the quality of the lives of many, many people.
Thank you, our IT, for that very informative video on illicit financial flows, which are an impediment to our efforts to raise resources domestically and to development in general in our continent. Thank you very much. We are not poor as Africa, but our choices are making us poor, because we have been told we are losing up to 50 to 80 billion annually, and that's double what we are receiving through official development assistance. And that is definitely undermining our financing of our health, our education, our infrastructure, our public services. And there's really need to make sure that we combat these illicit financial flows. And one way of doing it is we've come up with this model law that will assist our policymakers, our legislative drafters, to address all the relevant areas in need of legislative reform without usurping the powers of the powers that be of national legislatures to determine the context, extent, style, and form of their national laws. So without much further ado, we move forward on our program. We are now supposed to receive a presentation on the model law on public finance management. And Mr. Daniel Greenberg, our legal drafter, is a prior engagement today, but he is ably represented by Ms. Kahaki Jere, our learned rapporteur, duly instructed by Dr. Greenberg, who I said there's a prior engagement. So Ms. Kahaki Jere will take us through. As she takes us through, let us take note, let us park our comments at the end of her presentation, then we'll engage as we make interventions that will lead to our strengthening of this model law. Ms. Kahaki Jere, I give you the floor to take us through the SADC model law on public finance management.
Good morning, all. I hope you can see me, and thank you, distinguished facilitator Pepukai. I hope you're pronouncing your name well. So, Dr. Greenberg couldn't be with us this morning, but he has tasked me with the task to present the model law, which I believe has been ably shared to all participants. And we shall, in making the presentation, I shall give a general overview and highlight the main salient features. All protocols observed, and with due regard to the Honorable Secretary General, the Honorable Keynote Speaker, and all distinguished participants. And I also would like to thank the facilitator thus far. My presentation will be based on, like I said, the assumption that the model law is already given and shared, and I'll just mainly highlight the key areas. As we have seen in the video that was shown just before this presentation, there are many cross-cutting issues that lawyers may be involved in public management. Well, every day we hear of all these public financial management scandals, and they all, at the end of the day, hinge down on how strong our legal frameworks are and how enforceable they are. Currently, the SADC region does have public finance management legislation. However, this model law comes in to address some of the gaps that have been identified and supplement some of the areas that could be improved. And especially this session is for you as lawyers to scrutinize the particular provisions that need further adjustment and adaptability to ensure that the model law works for our SADC region. So just before going into the model law itself, I would like to just give a background on which the drafting of the legislation is based on. As we all know, legislation is meant to address gaps in our legal frameworks or address particular problems that have been identified in society. As we have seen highlighted in the video, the public finance management scandals continue to be perpetrated in our society, regardless of the fact that we have legislation. So This model law then, like I said, aims to address these gaps. However, in so doing, it has been constructed in a way that it aims to strike several balances between competing interests so that the law does, at the end of the day, become a workable legal instrument for our region. So, like I said, the model laws aim to strike several balances, and the first one is between simplicity and certainty. We have seen it is quite not so lengthy model law, but it does contain quite some detail that will be adapted by member states when it is adopted. So by the provisions aim to be as simple and as clear as possible, while at the same time providing sufficient certainty to make sure that the law is workable in our regions. And the second balance that the law aims to strike is between accessibility and accuracy. We all know that the users of this is quite a technical area, and the users of this law are both technical and citizens. So the model law is crafted in such a way that it is supposed to inspire confidence in the citizenry, that everybody should feel that they're able to understand its provisions, taking into account that it's quite a technical area, and that by the fact that the citizen is able to understand it and the theoretical underpinnings of that legislation, they're able to question and bring their respective governance institutions to check and call for them to account for what they're required to do as the public finance framework. The other balance that is sought to be struck is that between clarity and flexibility. So I'll highlight this towards the end by using an example. So the model law is also forward-looking in the sense that it does provide for eventualities that maybe as of now we don't understand yet. As well as we know that the law cannot provide for each and every eventuality, especially now in public finance management, because eventualities keep coming up. For example, we consider the recent trend which is going on, or rather the state of affairs that have been brought about by the COVID pandemic. Nobody foresaw this, but then our public finance management legislation has been there, and it has, to some great extent, still managed to work. But right now, we now have identified gaps that could be improved upon to cater for unforeseen eventualities and emerging crises. And another challenge when trying to strike this balance is because it is not possible to ensure that all the areas are covered. So the provisions are crafted in such a way to ensure that the principles that are highlighted in the law are robust and clear, but do give sufficient leeway to public officials to be flexible when a need arises. So one area of flexibility will be in the area of, for example, budgeting and public expenditure. For example, it provides for the leeway to have supplementary budgets and environments. As much as this is not the norm, but the law does recognize that there are instances where this need might arise and there is room for that flexibility. So, however, as much as it lays down the norm that should be used in all instances, there is that flexibility that the law provides for, while at the same time upholding that parliamentary oversight must be key in all the dealings of public finance management. And another balance that the law aims to strike is that between principle and enforceability. We as well as all know that we do not simply rely on morality. Yes, that is the underpinning of the legislation, but the law has to be enforceable. So the values on which the law is founded are provided for in the law, and these have to be well understood for them to be enforceable. So the principles aim to lay down the values and the principles on which the law is based, especially for instances where the court is called upon to interpret the law. So the model law in the preambular part does provide for the principles on which the law is based. And another key issue to take into account when considering this model law is the importance of contextualizing the model law jurisdiction. So the model law does give just a model framework, a broad-based framework to be adapted by individual member states when adapting this law to their particular legal framework. So in a way, it does aim to complement what, for example, is laid down in the individual constitutions of the SADC member states and the main overarching public finance management foundational legislative framework. So the ultimate objective is for the model law to fit in with the legal framework and not contradict the provisions that are already in our various jurisdictions. But where there's that variance, it aims to provide some complementarity while at the same time upholding the various principles that have been laid down. So that's just a general overview. Now I will go to the main parts of the law. The law, I will not share it, I will not highlight share my screen, but I will just highlight the main salient features of the various parts of the law. So the law is provided into 16 parts. We have the preambular part, which lays down the aspirations of the law and what it aims to achieve. Thereafter, we do have part 1 of model law, which provides for the scope and application of the law. The law will apply to governments and all ministries and state governments, local authorities, state-owned enterprises. So basically, the whole arms of government are covered under this law. And then we have part 2, which is a very key and important part of this legislation, which lays down the aims and objectives of the law. Clause 9 of, yes, sorry, can you hear me?
I request the participants to mute their gadgets. They are receiving feedback. Distinguished participants, kindly mute your gadgets. We are receiving some feedback. Thank you. You may proceed, madam.
All right, thank you. So part 2 of the model law lays down the aims and objectives of the model law, and clause 9 in particular provides for the purpose of this act. So the aim of this act is to foster accountability, transparency, and independence, and modernity by providing for an efficient and effective process to be followed in relation to the raising of public revenue, expenditure of public money and resources, the accounting of that money, and parliamentary oversight of public resources. These are very important objectives because at the end of the day, it flows down to what is provided for in clause 10, the measurable outcomes. This is very key because the citizens who will have access to the law should be able to hold the public bodies to account for the public funds, which at the end of the day are expended for the benefit of the citizen. So these measurable outcomes do act as a benchmark for measuring activities of public expenditure. So clause 10 lays down the main measurable outcomes. We have clause 10(1)(a), which lays that in exercising powers in relation to public financial management, public officials shall aim to optimize public revenue and expenditure. They're supposed to improve sustainability for future generations and to ensure that parliamentary oversight and accountability is as effective as possible. So these are the measurable outcomes by which citizens can hold their governments to account for the public expenditure of the public finance for the public citizens. Then the reason why these clauses are not in the preamble is because these are enforceable provisions. They can be used by the court to interpret the implementation of the PFM legislation. So we have seen that maybe some legislation does not have the particular measurable outcomes and the principles, but these are very key in ensuring that the model law aims to achieve the objectives that are laid down in clause 9. So without laying down the measurable outcomes and laying down the principles within which this law is supposed to be implemented, it might render it a nullity. So the model law does take cognizance of the fact that it is very key to ensure that the principles are included in the law. So clause 11 highlights the principles on which the law is founded on. So this includes a transparency principle, the accountability and participation principle, which calls on government bodies to be accountable to the citizenry and to ensure that the citizenry are able to participate and call on governments to account for how public expenditure is done. And then subclause 3 of clause 11 provides for the oversight principle. It gives and establishes, it gives functions and powers to the relevant bodies to ensure that these oversee the public financial management system in the respective jurisdiction. And then subclause 4 of 11 provides for the responsibility principle. This is very key because it calls on public officials and bodies who are exercising functions in connection with public finance management to have regard to their responsibility to exercise these functions in the public interest. Clause 12 lays down the values on which the legislation is based. This includes the values of integrity, independence and impartiality, equity, professionalism, accountability, and responsiveness of the public finance management to the needs of the individual states. So these are very key in the implementation of the model law itself. Then we go to part 3, which provides for the authorities underpinning public financial management systems, which include the finance minister provided for in clause 14. We have the finance secretary provided for in clause 15. The functions of the finance secretary are laid down in clause 16. And this, I draw particular attention to members to examine if this part sufficient addresses the roles that the finance secretary and finance ministry are required to play in the whole financial management system. Clause 17 gives powers of inspection to the finance secretary, who is empowered to call on public finance inspection. Sorry, I'll repeat that. The finance secretary has the powers to inspect public financial management process with the ministries and other public bodies. So it does provide a check because for the powers of finance secretary is enabled to check that the ministries which are applying this law do apply it in accordance to the laid down legal framework. And clauses 18 to 20 stipulate further the functions of the ministry and the minister. And then accounting officers are provided for in clause 21. The functions of these accounting officers are further laid down in subclause 3 of clause 21. And the roles include ensuring that these finance accounting officers establish systems that are effective and efficient and transparent in management of internal control of public funds. And these finance officers are called on to ensure that resources are applied effectively and efficiently. And they do have the obligations to respect tax, levies, duties, and that pension contributions and audits are fully complied with. These finance officers are called on to ensure that all contractual and financial obligations are settled in accordance to relevant legislation, and that money due to ministries are collected efficiently and effectively. So all these obligations as laid down in clause 22 through ranging from subclause A, paragraph A to L, are given to the finance officers, and as lawyers, we are called on to examine as to whether these are sufficient to ensure that the public finance duties of the government are carried out to the core. And then part 4 provides for public funds in general. Clause 24 provides for the consolidated fund, and clause 25 goes further to make provision for the payments made to the consolidated fund, and also makes further provision for payments by error in clause 27. Other accounts are provided from clause 28, which provides for retention accounts. So clause 29 provides for trading accounts. Then you have debt servicing accounts. And the part further makes for provision for gifts to the state and how these are supposed to be accounted for. The part 4 generally talks about public funds and how these are to be accounted for. Then we go to part 5, which makes provision for supply and appropriation systems. It talks about how appropriate funds are to be issued, appropriations in aid is provided for in clause 33. This part now leads us to part 6, which provides for parliamentary control, which is very key in public finance management. I would like to draw your particular attention to clause 35, which provides for the parliamentary engagement principle. This is a very key provision ensuring accountability of the executive arm of government. So Parliament, as another arm of government, does have a role to ensure that it checks the implementation of the obligations of the executive. So in particular, clause 35 provides that Parliament should use the full range of mechanisms available to it for purposes of overseeing and controlling the public financial management process. As such, it goes further to provide for mechanisms through which Parliament can do this, and this includes committee hearings and inquiries. So Parliament does have the mandate to establish committees and conduct hearings and inquiries on how the executive is spending public finances. Parliament can exercise this role through plenary questions during time of deliberation in the National Assembly, through written and oral questions, ministerial statements. And furthermore, Parliament and any committee may constitute other committees to lead inquiries, which will include external experts to investigate into any public financial management matter. As such, this requires that public authorities would have to prepare and submit work plans and implementation reports to the Parliament. So the whole clause does lay down a lot of obligations which the executive does have, and the Parliament can check at any point in time to ensure that the legal framework is complied with the expenditure of public finance. So as participants, you're called on to examine whether this adequately gives room for Parliament to check the executive in the execution of its functions. Then this part further provides for the appointment of the Auditor General in clause 36. It provides for the mode of appointment of the Auditor General. There could be various ways in the respective member states, but it ensures that there's the provision ensures that there's transparency in the appointment process. And then clause 39 gives powers to the Auditor General to review accounts of the government. So specifically clause 39, in addition to the specific functions of the Auditor General has the right to undertake a review of the accounts of other financial records and affairs of any public authority. And the Auditor General is given power to relay these reports before Parliament for scrutiny. And then clause 40 does provide for and recognizes the role of the National Audit Office and the general functions of that office. Clause 43 provides for audits and opinions. And then clause 44 provides for the Public Accounts Committee of Parliament. So as much as it is established in the National Assembly, it has a key role to play in the public finance management. And the model law recognizes that the Public Accounts Committee shall regulate its own procedures. However, the key role of that the Public Accounts Committee does play in public finance management is highlighted, and the model law takes cognizance of the particular functions the Public Accounts Committee does play. And clause 45 recognizes that the Public Accounts Committee—
I'm very sorry to interrupt. There are microphones on that should be shut. Kindly shut down microphones that are not supposed to be on. Thank you.
And how this shall be handled. Which leads us to clause 47, which makes provision for the complaints portal. So the Public Accounts Committee shall operate a system by which members of the public may make complaints to the committee to provide information about any matter connected with public finance management. So in a way, this provides a leeway for the public to be engaged in the public finance management of the government. So if there are complaints by by citizenry about how the executive is expending funds. They do have a leeway to channel these complaints with the complaints portal and the Public Accounts Committee through its powers to check the executive has powers to ensure that the executive is called into account in relation to the complaints that are laid for it. And then furthermore, clause 45 provides for whistleblowing, which also includes, this shows that the citizens will still be engaged in public finance management. And under this clause, the Public Accounts Committee shall make arrangements to ensure that public authorities and other persons with information about an actual or possible financial irregularity are enabled to make disclosures to the PAC. So as we saw in the video that was shown earlier, whistleblowing does help in resolving all these public finance scandals, and if this is entrenched in our legislation, it serves as a mechanism in short to try and ensure or curb the effects of public finance mismanagement. This clause further confers protection on those persons who act as whistleblowers, and by linking this with the whistleblower legislation, if it is available in the various member states. Then Part 7 provides for the national budget, and these are some issues that require further consideration. This part provides for the purposes of the budget, and clause 51 makes provision for parliamentary control. So under this provision, the Minister of Finance shall make arrangements to ensure that Parliament has opportunity in the course of application of this part to object individual budgetary proposals of the government, to require the implementation of specific recommendations on public expenditure, or Parliament to give or withhold approval to particular components of the public finance management systems. So in a way, it does highlight the importance of the checks and balances between the two arms of government. So when the executive does present the budget, the proposed budget to Parliament, Parliament has overall scrutiny powers to ensure that the proposed expenditure does ultimately benefit the citizenry. Then clause 52 provides for the annual appropriation procedures. Clause 53 is one of the flexibilities provided for, as highlighted in my opening remarks, with regards to the flexibility that this legislation provides for. It provides for requirement. So this is not the norm, but this is always the exception where something has to be covered within the national budget, which was not yet anticipated. And then we go to clause 57, which provides for budget consultation, which makes room for participation of the citizenry and the Parliament. And then clause 62 highlights the importance of equality and diversity in the annual budgeting from the financial year of the government. And then the rest of the part goes on to highlight all the steps that should be taken and principles to be taken account in the annual budgeting process. Then we go to part 8, which provides for government borrowing and public debt. Clause 72 classifies the public debt, and clause 73 provides for the debt management strategy. It obliges the minister to prepare and lay before Parliament a debt management strategy. As we're all aware, most member states might have high debt because of maybe not so appropriate planning. So this provision makes sure that there is a legal framework on which public debt is managed. It further provides for debt management committees in clause 74, and clause 75 gives the Minister of Finance the authority to borrow, but this is subject to Parliament approval. And then clause 77 provides for the issuance of securities and registration of that securities under clause 79. And clause 80 gives power to the government to on-lend finances that have been borrowed and as such, there will be a requirement for guarantees and indemnities which are provided for in clause 81. And then clause 82 calls on for the minister to make public debt statements and to ensure that there's information about resources allocated or available for allocation to cater for public debt. And then clause 83, which is quite important, highlights the debt schedule which the minister is supposed to develop. So the clause 83 provides that the minister shall maintain a public debt schedule setting out the state of public debt from time to time. So this is an accountability mechanism to ensure that the citizen is aware and that the parliament does keep the executive in check. And then the rest of the part goes on to parliamentary scrutiny and how the parliament ensures that debt is serviced and gives obligations to the minister on how to recover debt or to government as well. Then we go to part 9, which provides for procurement and use of public resources. Most member states do have separate legislation which addresses this, but the public finance management does take cognizance of the important role that public procurement and use of public resources does play in the whole public finance management system. So therefore, clause 90 provides for public procurement activities as a general definition, and the procurement principles laid down in clause 91, which is that the public procurement activities should be carried out with a view to achieving and in a manner designed to achieve maximum value for public expenditure. So value for money at the end of the day is supposed to be achieved in all public procurement. And then clause 94 goes further to provide for the procurement regulations, as much as this could be in separate legislation. The public finance management model law does take cognizance of the important role that the procurement regulations do play in complementing the PFMA model law. And clause 95 further goes to highlight how the use of public resources should be used in public procurement. And then clause 95 is quite key because it highlights the procurement in emergencies. This will usually happen in circumstances not usually covered in the national budget. So there would be some need for flexibility. But then clause 97 calls on that procurement regulations that are developed pursuant to this part should include provisions about the application and modification of the regulations where procurement activities are required to be undertaken in connection with or during the course of any civil contingency or other emergency. For example, COVID is a very key example in this case where this part is appropriate. Then part 10 deals with public accounting. Now we'll highlight clause 99, which provides for resource accounting as distinguished from cash accounting, which is a trend which only shows the movement of cash and is not an accurate representation of public assets. However, this is laid down in clause 99(1) and states that the ministry for which an estimate is provided for in Parliament in respect of any financial year shall prepare resource accounts for that year. So it singles out resource accounting as opposed to cash accounting. Then scrutiny of that accounting is provided for under clause 100. Then we go to part 10, which provides for public accounting. So clause 98 provides for the public accounting principles, which include the public financial management principles and the generally accepted accounting principles. So it does lay down the public accounting principles to be used in public accounting. And then clause 99 provides for preparation of resource accounts. And then we go to clause 100, as I've already highlighted, on the scrutiny of that public accounting. Then we go to part 11, which provides for financial misconduct, misuse, and maladministration. So this is a very key part in enforcement of this legislation. And it starts by defining who a public official is, because this is the official that has the obligation to implement the public finance management obligations. and also is called on to account for that financial management. And any breach of the obligations laid in this act would be termed financial misconduct, misuse, or maladministration. So then clause 109 goes on to lay down the public financial misconduct, and the penalties are left to the individual member states to decide based on the gravity of the misconduct. And then clause 110 lays down misuse of public funds as one of the misconduct. And clause 111 is quite key because it states what maladministration is. And this is a broad term that needs to be scrutinized as to whether it is adequate in this particular scenario. But to a greater extent, the model law does try to capture the scenarios that may be considered as maladministration. And then clause 112 provides for the enforcement mechanisms, which include recovery of funds, disqualification of public officials under clause 113, which provides that a public official has committed a financial maladministration may be disqualified from a specific office or appointment or class of offices or appointments by resolution of the Parliament. So Parliament does have a crucial role to play in checking this and disqualifying some members of the executive for maladministration in carrying out the obligations of public finance management. Then part 12 is quite key, it's different and new. I think most jurisdictions may not already have provided for this. So it is one of the flexible areas of the legislation which provides for cryptocurrencies. As we are all aware that it is not quite clear how this is governed, so it does lay down the regulatory principles in clause 116, but before that, there's a definition of cryptocurrency given in 115 to try and give a scope which this part shall apply. And then clause 116 does lay down the general principles for regulating cryptocurrencies, which include constructive engagement during the regulatory aspect, and the classification of crypto assets to be defined and then classified so that the law is very clear as to how it shall apply to these crypto assets. And then it also ensures that there's consumer and investor protection in the regulation of cryptocurrencies. So these are the general principles, but then it goes further to provide for flexibility on how to regulate this by making room for regulations to be developed as and when needed and when changes occur in this ever-changing mode of finance. Then part 13 provides for state governments, and the interpretation is provided for in clause 120 that this shall apply to state governments and this shall be adapted as according to how legislation is drafted in the particular individual SADC member states. And 121 is a general application of this act. And then part 14 provides for local authorities. It takes cognizance of the fact that some individual member states already have legislation in this area, but then it still is key to have local authorities covered under public finance management. And then part 15 provides for state-owned enterprises. These are defined, since these are public bodies, they are also covered under the public finance management law. Then part 16 contains the final provisions, include contraventions of the act. Clause 126 provides that it is an offense to fail to comply with the obligation listed in this act. So it's open to individual member states to classify the particular offenses. And subclause 2 of 126 provides for the penalties which are left to the discretion of the individual member states when adopting model law. Then the other latter provisions are standard. Clause 29 provides for supplementary regulations, which takes cognizance of the fact that the model law will not cover everything, and the minister does have a leeway to make regulations to supplement the act and to and the minister will also make guidance. This can be done with the minister, the secretary of the treasury, the accountant general, the auditor general, and other relevant authorities. then these regulations are subject to parliamentary scrutiny as provided in clause 132, which still upholds the parliamentary oversight principle and affirms the role that Parliament does play in ensuring that there's accountability in public finance management. Clause 133 provides for commencement, and the latter part, including transitional provisions, repeals, and revocations, shall be adopted in accordance with the individual SADC member states. The schedules are there just for guidance, so these do form part of the law, but will be adopted by the member states in accordance to how their legislation is structured. So in a nutshell, this is what the PFMA model law does provide for. Thank you. So questions and comments shall be taken. We have a rapporteur here, and the comments and contributions to the model law, specifically to improve the model law, are welcome, and this shall be relayed on to Mr. Greenberg. Thank you.
Thank you very much, Madam, for that elaborate presentation on the model law on public finance management. Colleagues, we have been taken through the model law on public finance management, and we are now going to open the floor for any interventions, comments, suggestions on how to improve the draft model law that has been laid on the table for us. We will open the floor for any comments if participants can show by raising hands, and I'll kindly ask participants perhaps to just introduce themselves as they make their contributions so that we know who is representing which organizations when we make our contribution. Before we go in country by country, the floor is open for anyone just to show by raising of hands who may want to make any contributions. Then we'll then go country by country if time permits. Thank you. The floor is open. Let's make the contribution. Distinguished participants, can we show by raising hands those who want to make contributions? Hello. Anybody to break the ice and make the first contributions? Or we are still digesting what has been presented before us before we can make contributions? In that case, then we'll have to go country by country. We do a roll call so that we make contributions as per our countries. I'm not sure whether Angola has managed to join us. Angola, Botswana, DRC, Eswatini. Do we have representation from those countries? Anyone from Angola, Botswana, DRC, or Eswatini? If not, we proceed to Lesotho. Distinguished participants from Lesotho, you can proceed, just introduce yourself, then you make your contributions. If not, you just introduce yourself so that we know you are here and you don't have any contribution to make.
Hello.
Hello, please proceed.
Thank you so much. I'm Mamufute Gale from Lesotho. I'm a lawyer by profession. I'm currently working for SAFAID. I really don't have so much questions regarding this model law, save to applaud the drafters of the law. We are still digesting, and I think we are very happy it has opened our eyes in terms of accountability, in terms of public finance management, which I, for one, I didn't know that lawyers have that big role to play in terms of public finance management. I'm really grateful, and we have learned a lot. And as the law is finalized, or as you finalize everything as SADC, at the SADC level, we'll make sure as lawyers that we push countries to adopt the SADC model, because I really think it's going to keep so many things. It's management of funds, but of importance also looking at the funds that we have lost through illicit capital flight. I'm really excited, I'm really excited, and we can't wait for the adoption of the law. Thank you.
I don't actually want to reduce the payment. I want to finish sooner because there's
Hello. There's someone who is speaking. Hello, colleagues. Can we mute our microphones?
And I will shout. Okay, sure.
Colleagues, can we mute our microphones? Thank you. The distinguished participant from Lesotho can continue.
Should I start over?
No, we had you. If you have any more.
Thank you so much. I thought, okay, thank you.
No, we had you.
Thank you.
Thank you very much. I hope you are done.
Yes, I'm done, sir. Thank you.
Thank you very much. Thank you for that contribution and comment. We proceed to Madagascar. Distinguished participants from Madagascar, you can proceed to maybe introduce yourself and make your contribution.
This is the interpreter. There seems not to be any sound coming from Madagascar.
Participants, I will kindly request that when you make your contribution, if possible, you unmute your video for the purposes of recording so that people can see you. As you unmute your mic, you are also requested to unmute your video so that people can see you, because this is being live streamed on YouTube and on, I think, on Parliament TV as we speak. Distinguished participants from Madagascar, the floor is yours.
There seems to be no one speaking from Madagascar. This is the interpreter.
We may have to speak Madagascar for now and proceed to Malawi. Distinguished participants from Malawi, the floor is yours. Do we have Malawi in the meeting? Malawi, I'm calling upon you to make your contribution. I hope they will make their contributions as we go. I'm just calling upon if distinguished participants from Mauritius, Mozambique, Namibia, Seychelles, and South Africa, if they've joined us, can you show by way of raising hands, or you unmute your mic and make a contribution? Mauritius, Mozambique, Namibia, Seychelles, South Africa. Do we have participants from those countries? Do we have representation from Mauritius, Mozambique, Namibia, Seychelles, South Africa? If not, we proceed to the United Republic of Tanzania. Distinguished participants from United Republic of Tanzania, you can unmute your microphones and videos, introduce yourself and make your contribution. Hello, Tanzania. Tanzania, can you hear me?
Hello. Yes, it's Hafsa from Tanzania. I followed.
Thank you very much.
Yes, I don't have anything to contribute for now because I participated as just another participant. I was not a delegate, but I was following up very closely. Thank you for each delegate and their presentation. It's really good. And yeah, thank you.
Thank you very much. Thank you. It's good that you are with us. We proceed to Zambia. Our distinguished delegates from Zambia. The floor is yours. Zambia, the floor is yours.
Just in case the other delegates are looking to me, I am here representing SADC lawyers. So I've seen there's Mary Mlenga, there's Wale Muvanga. So please feel free to contribute.
Sure, if you don't have any contribution, you can just unmute your mic and your camera, you introduce yourself, then you indicate that you don't have anything to add. And those who are going to make written submissions, you can indicate so that you are going to send in written submissions, and they are very much welcome through the SADC Parliamentary Forum to Mr. Daniel Greenberg, our legal drafter. Thank you, Zambia. Seems there is no one from Zambia who is hearing me. I have to proceed to call upon Zimbabwe to make their contribution. Distinguished participants from Zimbabwe. Hello, distinguished participants. Are we together? Are you following this meeting? Anybody from Zimbabwe or Zambia?
Yeah, through you, Mr. Chair.
Yes, sir.
Sure. I think while colleagues are still probably ruminating on the presentation, just to make a general observation with regard to the content of the public finance management model law, with regard specifically to the legal profession. You know, one of the key issues which I did pick up from the keynote address was that while lawyers are placed in very vantage points in regards to reporting, assisting in financial transactions, especially advising, and in many cases signing off on the legality of those transactions, you find that this is done by a law firm and expert lawyers. They have a very peculiar challenge in that they are conflicted when it comes to certain duties that are obviously vested in the legal profession when they work with their clients. So you talk of the attorney-client privilege and the requirement to disclose when certain things are obviously not above board. Lawyers, the debate has been going on, and I think I'm calling upon the drafters to keep thinking about this issue of disclosure when it comes to lawyers, both in government and outside of government, because certainly there is a level of disclosure that they must make, but there is also a certain level of disclosure that they cannot make. And this has been the reason why issues of illicit financial flows and financial intelligence have been at loggerheads with the legal profession. And right now there's a huge debate on how the legal profession is going to reform self-regulation in order to meet the financial transaction standards of the global flow of capital. And in many jurisdictions, this has changed. I think Canada is one jurisdiction that I would encourage, the drafter to look at, so that you can find out what sort of concessions the legal profession has made in self-regulation, and how this can be reconciled with the realities or practicalities on the ground in the jurisdiction that we have. So that was just on the back of my mind, not to prescribe any form of drafting per se, but to say, can we look at some external experiences while we borrow best practices?
Thank you very much, sir, for that contribution on the issues of conflict and the need for self-regulation. I hope our rapporteurs have captured that. And if there is anyone who wants to make a contribution on the same subject matter or a response, you are welcome to do so. And if there is anybody to make another contribution, the floor is open. Distinguished participants. Hello, sir, you can proceed. Mr. Solonia Ina, you can proceed.
Oui, merci, monsieur le...
Thank you very much, Mr. Facilitator. Ladies and gentlemen, good morning. Sulamiana Adramana, this is my name. I am representing the Council of Lawyers in Madagascar. We would like to commend the organizer for having taken the initiative of developing this model law. I think this has come at the opportune time, given the fact that here in Madagascar, the head of the state and the judiciary, they are advancing the policies that have got the same objectives and the spirit of this model law. Here we talk only about what happened this year. A lot of managers of public finance are being arrested for financial abuse and the lack of respect of the laws related to public finances. That's why we are encouraging you to continue to work on this model law in the interest of the general interest of the populations in the region. I thank you.
Thank you very much for that contribution and encouragement and sharing such information. We feel encouraged, and indeed what we are doing will make an impact in the region and across. Thank you very much for that. Any more contributions, distinguished participants? I see a hand. I see a hand from Mr. Solonia Ina. I'm not sure if it is a new hand or it's a hand that you raised when you spoke earlier on.
Je suis désolé.
Says he's sorry. It's the old hand, I presume.
It's okay. We can proceed. Any more contributions, colleagues? I don't see any hands, and I have to do again a roll call to be sure that there's no one who is left behind in terms of making contributions. Starting with Malawi, who had indicated that they are participating in the meeting. Malawi, do you have any contribution or we proceed? If not, I'm calling upon Tanzania. If you have any contribution. Zambia, any contribution from Zambia? And lastly, Zimbabwe, any contribution from Zimbabwe? Thank you. I don't see any hands. And colleagues, kindly note that you are free to engage with our model law drafter through the SADC Parliamentary Forum. Your contributions are most welcome. You can send in written contributions through the Secretariat at the SADC Parliamentary Forum. I now hand over the floor to representatives from the Secretariat at the Parliamentary Forum for any final words before we close the meeting. SADC PF. Hello, anybody from the Secretariat?
Hello? Hello, am I audible?
Yes, we can hear you.
You needed somebody from the Secretariat?
Yes, I realized that we don't have any more contributions from the distinguished participants. So we wanted to close the meeting and I was inviting anybody from the Secretariat maybe for the final words before we close the meeting.
Just a moment, let me just get Ms. Yapoga in.
Okay. And I'm sure colleagues have the contacts. If not, they can be shared on the chat platform so that they can send in written comments or suggestions to the model law drafter and the TWG through our Secretariat. I'm seeing they've shared the email So suggestions and contributions can be sent through pfm@sadcpf.org. pfm@sadcpf.org. Madam Jere, I'm not sure if you want to react to the comments that have been made. You can react. The floor is yours, Madam Jere, if you want to react to the comments.
Thank you once again, the guy. I still hope I'm pronouncing it right. And to all the, all right, thank you. And to all the distinguished participants, and comments, and that they do recognize the importance of this legislation, but as highlighted by one of the participants, who's also the rapporteur, that the importance of the public finance management law cannot be overemphasized, and the role that the legal fraternity does have to play. As much as they do, it's very true that you have one engaging the state to ensure that the law is upheld. So in this case, maybe participants could think around that, as called on upon by Mr. Nyamani, to try and give suggestions on how best we can improve this. We do have the whistleblower protection provisions and the whistleblower provisions which provide for whistleblowing in the case of misuse of public finance and general public finance management. However, it's just about striking the, maybe one of the things that the law should is strike the balance between the obligations in other provisions and that the obligations that citizens have under the public finance management legislation. But all the comments that are made are welcome, and as you have highlighted correctly, the consultations are still ongoing, and the SADC is still open to receiving more suggestions, comments, areas of improvement. After all, this model will be used in the SADC region and to the benefit of our citizenry, including the lawyers themselves. So with those few remarks, thank you on my part, and we look forward to the further comments being made.
Thank you. Thank you very much for that response. I'm not seeing any hands or anybody interested to make any further comments. I had requested for the Secretariat to give us the way forward before we close the meeting. Do we have any member to give us the parting shots before we close the meeting?
Good afternoon, Mr. Shigore. No,
yes.
We don't have anyone officially coming to close the session, but we have come to the end of the session, and we would like to thank everyone of the distinguished participants who participated in the session today for availing their time and taking and providing comment on the draft. And we request them to also submit their written comments on the email that has been provided on the chat box. And also, thank you very much for participating. And yeah, that's it. We can close the meeting, I think.
Thank you very much. Have a good day, everyone.
For availing their time and taking and providing comments.
Bye, everyone. Thank you very much. It was a pleasure interacting.
Thank you. Thank you for.
Bye. Thank you.
Bye.